Thank you for having me. I wanted to start by telling Harun I'm very interested in the work they are doing identifying Israeli soldiers and potentially binationals. I think it's very important that we think about initiating legal actions domestically also against these people, and I would love to be in touch with you, Harun, regarding the potential for identifying Canadian Israelis that may have been involved in war crimes and genocide in Gaza. I'm saying that because I'm one of the founders of a Canadian organization called the Legal Center for Palestine, LCP, and basically we are representing and defending Palestinians and pro-Palestinian voices in court. And we have a series of strategic cases. Now we are suing the Canadian government very soon in the next week or two for its violation of international law obligations to prevent genocide under the Genocide Convention, and how that also violates charter rights in Canada of our, and I apologize for the expression, clients who are two Palestinian Canadian victims of genocide. And next step, we want to initiate actions against Canadian Israeli individuals. So I think the work you are doing there is very interesting. Now, having said that, look, what I will say is not a call. It's not a call for the abandonment of international law or anything like that. I'm a lawyer, after all, and professor of international law. So I'm not calling for the abandonment of international law. But I would make a call to have a more critical perspective on international law and the capacity, the power of law to fulfill the promises that it makes, right? And for that, I wanted to give you an example. I mean, we all know that the international legal system is caused by power dynamics, right? I mean, we see it all over the place in the Charter of the UN itself, right? After Article 2 saying that one of the main principles of the UN Charter is equality of sovereign states, right? Article 25 already starts making distinctions between states, and Article 27 crushes the promise of equality between states by giving some states the veto power, right, and not to others. So we see how the international legal system actually betrays its own promises, and we know why. We know that it is because there are power dynamics, very strong power dynamics, driving the entire legal system. Well, that is not courts. International courts are not an exception to that, right? And we saw it with the case of genocide in the International Court of Justice. I was surprised myself. I'm Palestinian. I was born in Chile, but I come from a Palestinian, both sides, Palestinian families, and I was very surprised when the decision, the first decision of the ICJ came out regarding the provisional measures, right? I mean, the court was telling us in this decision that there were grounds to believe that a genocide happening in Gaza was plausible, right? And at the same time, the court tells us that the situation is so serious that it deserves, it merits the indication of provisional measures. But surprisingly, the court orders a series of provisional measures, but it does not order the only measure, actually, that had the potential. I'm not saying that it would have done it, but it had the potential to stop the genocide, which is a ceasefire. And when you so the court was telling me, look, I think a genocide plausibly is happening there, and the situation is desperate. So I'm indicating provisional measures, but I will not indicate the only measure that could have the potential to stop the genocide. How do you explain that? So many pro-Palestinians and Palestinian legal scholars were very welcoming of the decision. And I was surprised that nobody was actually making a critique of this court and its decision, because the decision deserves this critique. I mean, They were saying, no, it's just that the court cannot order a ceasefire, a unilateral ceasefire, because ceasefires are bilateral or multilateral. This is not true under international law. The others said that no, the court was coherent with the previous precedents of the court because it has never ordered a ceasefire to anyone, which is not true neither, because in the case of Russia-Ukraine, the court did order a unilateral ceasefire. So proves my point, actually. So what this shows is more complex and actually adds insult to the injury, right? Because what the court was coherent with is with its distinction between a genocide happening to Black or brown people compared to a genocide happening to white people, right? In the case of white people, the court will, with no problem, order a ceasefire to Russia. Rightly so, I think, right? But in the case of Palestine, they would not order a ceasefire. Why they didn't? Well, there is no legal or factual reason that can actually justify this decision. And my only explanation is that the court is crossed by the same power dynamics, right? And we should be aware of this, because people are betting so much on the international courts that I see how people get frustrated, disappointed, discouraged. Why? Because they cannot understand how and why, if the international legal system was supposedly established to eradicate violence, right, at the international level, these things continue happening. Well, when one is aware of these critiques and the dynamics inside these institutions, one realizes that actually the international legal system was never meant to eradicate political violence at the international level, but rather to administer colonial and imperial violence. And this is what we see, right? I mean, in the case of Ukraine, we condemn. In the cases of Israel, we don't. Some violence is legitimate, other violence are illegitimate. Some people have the right to defend themselves, some other people do not have this right, etc., etc. They are not trying to eradicate violence, but actually they are trying to administer violence, I would say, along colonial and imperial lines. And when one adopts this principle of the administration of violence, well, one can make sense of the international legal system and what is going today. So so we know that a genocide is going on, right? Despite all the accomplices of the genocidal state trying to convince us every day on TV that we are actually not seeing what we are seeing, right? Despite that, the genocide is going on. And actually, you know, the critique to the court could be a damning critique, because actually, if you bring the argument to the end, well, I cannot conclude anything else but the fact that going to the ICJ, we were hoping for a stop to a genocide, and what we got was actually a genocide legally legitimized. Because the Israelis were right when they were saying, well, the court did not order a ceasefire, so we are legally entitled to continue shooting. And this is what they did, right? So then the conversation and the whole debate was about proportionality, distinction, and whether the Israelis were doing everything in their power to avoid killing and etc. I mean, you see the absurdity of it? Actually, yeah, I finished with that. The absurdity of it is that this legal case and the decision of the court put us in the absurd position of having to sit with the perpetrators of genocide to discuss whether they were doing everything possible in their power to avoid what they publicly and explicitly said they wanted to do, and they were actually doing. So, I want to finish by saying a call to our audience. You know, many people tell me, why should I be concerned? This is so far away from me, etc., etc. Well, if you think that you are too far away to be concerned, you are, I mean, so wrong, because actually the message is very clear. The message is that today, genocide is actually a political alternative, you see? And that can happen in Palestine, or anyone who opposes and represents a threat to things that matter for Western powers. Meaning what? Israel? basically, and their economic regime. So today we are, in front of this very likely explicit possibility of genocide as a political alternative. Thank you so much.